We have our new segment of the podcast that's called "Ask the Lawyer," and we have my good friend David Mordekhov, who's an attorney in the state of Washington, and he's actually practicing personal injury law, and we have him on our show to talk about legal aspects, legal profession, and just answer legal questions. David, how are you doing, my man?
Hey, Pavel, good morning. Thanks for having me back. It's good to be back.
Thanks for joining us. Well, when I talked to you after our episode that we had a lot of positive feedback from people because apparently people during this pandemic they do have questions about legal aspects or legal questions, and sometimes they need to talk to a lawyer, and I figured what's the best way to do that if to bring the lawyer to them on our podcast who can answer questions and you know sometimes talk about what's been going on and how things are going. So, David, tell us something about yourself. I know you've been in the legal profession for quite a while, right? So why don't you tell our listeners who you are, what you practice, and how long you've been doing it?
Thanks for the introduction, Pavel. First of all, let me just comment on what you just said about our audience. We did get some very positive feedback from our listeners, and in my experience, anytime you take an average human being and if you stop them and you say, "Do you have a question for a lawyer?" Most of people will have a random question for a lawyer, something that comes up in their life where they need some input or an advice. I guess in law school we call it curbside opinion or curbside view, where people catch you in the corner and ask you questions. So, and I think part of what you and I decided to do here with Ask the Lawyer is kind of open up this forum for our listeners to ask questions in case there are any issues. So, going back to my background, I've been in practice for over 20 years, and my practice is almost exclusively personal injury, so civil litigation, torts, and we do both plaintiffs and defense work. Also, in addition to my sort of day job, I also act as a volunteer at the King County Bar Association Neighborhood Legal Clinic, and I've been doing that
Oh,
for about a decade. And so, the subject of today's podcast really, I found my inspiration for this rubric based on my experience working with the um, people who come to our legal clinic with questions. The way this works, and maybe I should just go ahead and do the plug. I don't have any interest or financial gain in advertising this, but I find that this is a very useful resource and it's greatly underutilized. So, King County Bar Association, if people go to Google and enter Neighborhood Legal Clinic, you're going to find as a list of different locations where people can go with their legal questions, and all you need to do is show that you are a resident of King County. You don't need to qualify based on your income. You don't need to qualify based on any other factors other than that you live in King County. And so this is where I volunteer. This is where I see clients about once every month, and we spend about 30 minutes with a given person. And for that 30-minute period of time, they're my client. I'm their lawyer, and we talk out, sort of talk about their problems and issues. So, in the course of that experience of acting as a volunteer, I've been seeing some patterns of common misconceptions, common misunderstandings about the legal system in general, and some of the myths about the certain practices, certain areas of law. So, this is what I thought we would discuss today in your podcast, Pavel.
that's correct. That's correct. And there's a lot of myths and a lot of ideas about what lawyers do or what are the legal problems may be, what are the solutions to legal problems, and we obviously cannot cover everything in one podcast episode. That's why we decided to make it a segment of the whole show and do it on a continuous basis, where you'll be debunking those myths for the public. So my understanding, you provided your services for free to the public while volunteering at the King County Bar Association clinic. What's called the pro bono hours. That's what you do, right?
That's
And I think every lawyer is required to do that, right?
Actually, no, you're not required to put in pro bono hours. That's one of the myths. Thanks for asking. It's a myth.
Yeah.
Let me debunk it. You don't have to put.
Yeah, let's do that. Let's start with that.
You don't need to put in pro bono hours. Every single volunteer lawyer you cross paths with, at least in the state of Washington, is doing that because of their calling, because they believe in it. I mean, that's the reason why I do it. And I would say that probably some of the most meaningful client attorney experiences I've encountered in my life had been through that legal clinic.
Well, and it's very admirable because another myth that people have, that lawyers make a lot of money. Well, maybe they used to back in the days, but right now I don't see them making a lot of money, like a lot of money, like like people think they make. So that's probably another myth, and probably working sometimes pro bono actually helps to put the name out there and helps you to help somebody to get exposure to clients and just gain more experience, right?
Yeah. Well, this might be a good question for you, Pavel, actually, because I imagine if lawyers were making big bucks like a lot of people think, you wouldn't be bothering with 3 startups. You'd be practicing law.
Probably that's one of those reasons exactly that I don't practice law, and I really admire people who do. I really admire people who do because I went through law school. I got my law degree, but at the same time, I realized that there are other ways that I can spend my life doing something that's, I guess, more fun, and less work, and and less headache. Because again, a lot of people think that well, here's just the myth that people usually think: lawyers make a lot of money, it's easy, and lawyers are crooks. And if the general public puts real estate lawyers, members of the Congress, and car salesmen and lawyers on the same pretty much pedestal, like they're crooks. Like real estate agents, lawyers, car salesmen, and members of Congress. Interesting.
Yeah, that's an interesting stereotype. Another stereotype that kind of
Yeah.
goes along with what you just mentioned is this whole idea that Americans, by and large, highly dislike politicians, highly dislike lawyers, and highly dislike used car salesmen. They love nurses and vets.
Correct. Yeah, not doctors, but nurses and vets. David, we have a question here from Adam. Adam's asking, so personal injury lawyer can only handle car accidents, right? What about somebody got bitten by a dog? Can personal injury lawyer help with that? And how does it work?
This is definitely within the purview of a personal injury lawyer. There are lawyers out there who specialize on dog bites specifically, but by and large, this is part of my practice. I do dog bites cases all the time. And it's quite convenient that Adam asked us this because one of the myths that I was going to debunk with you today is this whole idea that every dog is entitled to one free bite. I don't know if you've heard that expression before.
I've heard about it. Yeah, I
What?
know exactly what you're talking about.
Uh,
It's a myth. Yeah.
let's unpackage this a little bit. So basically, it's a common law doctrine that says that before an owner of the dog can become liable for the attack by his or her dog, they need to be on notice that the dog is vicious or dangerous. And the best
Hmm.
way to be put on notice of your dog's dangerous propensities is to have an incident where your dog attacked someone. So
Basically, the dog has to bite somebody,
exactly.
right?
So hence this myth that every dog is entitled to one free bite. In other words, the dog owner is not going to be held responsible for that first bite. Now, once the second bite occurs and the dog owner is on notice of that, then liability would arguably attach. Now, in the state of Washington and many other jurisdictions, that is no longer the case. There is actually a statute in Washington that says that regardless of whether or not you're aware of your dog's dangerous propensities, if it attacks someone, namely if it bites someone, you are strictly liable. It doesn't matter whether you knew or not, you are on the hook.
strict liability, you may want to explain to people what strict liability is, because we have listeners who do not have legal training, and sometimes people don't understand that.
And strict liability is exactly what I said. Essentially, it doesn't matter how much culpability you have. All that matters is that the accident happened. In order for an injury victim to prove that the dog owner is liable because of a dog bite, all they need to show is that the dog A attacked them, and B, the attack was not provoked by the injury victim. That's all you need to show.
Let's switch gears, and somebody else is asking a question here. We are in the middle of the pandemic, so and Congress is discussing about something limiting liability on business owners for people who may get exposed to COVID, or patrons of a business. Is there anything like this right now in the state of Washington where people who get COVID can actually go back to sue the business that exposed them to COVID, or either it's a patron or it's a employee? Is there anything like this right now currently in the books in the state of Washington, or at least any case law that's being tested right now?
This will be subject to general common law of negligence if a victim, in this case someone who contracted COVID or someone who incurred damages as a result of someone else contracting COVID, would have a claim against the premises owner, assuming that the premises owner was aware of the virus and didn't take steps to protect the person, the visitor or the patron, whoever the case may involve. Now, there are some states, and I think Washington is one of them, which is now discussing a new legislature, the new statutory scheme, which would provide immunity to premises owners and to businesses against claims involving COVID. And I think part of it is because the industries have been impacted so heavily by this pandemic that allowing a wave of litigation, which is almost certainly going to follow,
And it's going to bankrupt the businesses.
is going to essentially drive them deeper into the ground. So, as far as
Exactly.
I know, the Washington has not promulgated the legislature which would protect and immunize business owners from claims based on COVID and virus shedding. But this is something that I'm looking forward to see what our legislature would do, because part of me, the part of me that wears the defense lawyer hat, really wants that legislature to be in place to protect business entities and business owners from a wave of new litigation in the wake of COVID.
But right now we don't have that protection in place. So pretty much anybody can walk into the store and think they got COVID there, because again we have to go to the causation to prove the causation that it actually that person, to translate it into English, we need to. I mean, the plaintiff must prove that they specifically caught COVID at that place of business that where they went, which means they have to be certain. Um, yeah, they have to prove that it happened there, and also damages is another thing to prove if somebody has been asymptomatic, no other, nothing really serious. Well, not a lot of damages.
That's a good working definition, Pavel. Another thing that keeps coming up a lot in the wave of COVID cases, COVID claims, COVID litigation is what's known as a force majeure provision in a lot of
Mhm.
contracts, which
Act of God.
provides act of God is a little different along the same lines, but essentially force majeure says that if performance under a contract is impossible because of circumstances which are outside the circle of influence of the parties who signed the contract, then the contract is not going to be enforceable. And we're seeing a wave of litigation based on breach of contract claims where the litigants are trying to sort out in front of a judge whether or not force majeure involves things like the global pandemic. And different jurisdictions come out differently on this issue, but there seems to be a common pattern where a judge is not going to enforce a force majeure clause unless there is a specific language referencing a virus, a pandemic, I mean, I wouldn't expect the contract, pre-March
Well,
2020 contract, to reference COVID by the name, but words to that effect which specifically identify COVID as a problem.
well, and I think force majeure. To be honest with you, the force majeure provision of the contract would probably be more applicable back in March, April, May. Right now, we're in month 7 of this madness, so that's pretty much becoming way of life right now. So, I mean, the force majeure would be, a normal life, pretty much. But that's another discussion. We have a couple more questions here from the audience. Susie's asking. Susie says, "I fell and broke my arm at work due to the fact that the floor was wet and there was no signs. Can I sue the employer?"
So I would need to ask Susie a clarifying question. Let me answer this in general terms, and then maybe while I'm answering, maybe Susie can type up a follow-up response. The answer is going to depend on whether or not she fell on the premises which is owned or operated by her employer. So, Pavel, if you can keep an eye on the message box, see if Susie will let us know whether or not
Yeah, yeah.
that's the case. But in the meantime, open it up to the general public, and without the specific nuances of the employee-employer relationship, those slip and fall cases definitely get filed all the time. We see quite a few of them. Slip and fall, trip and fall, tumble and fall cases are generally much harder to prove on liability than, let's say, a rear end collision involving two vehicles. And the reason for this is that every person who walks down the street, who walks into a business, who enters your house, Pavel, who enters my house, has the duty to see there what's there to be seen, and they have a
Mhm.
duty to protect themselves and others from injuries and damages. What that means in the premises liability case, and slip and fall cases are generally fall under the category of premises liability cases, and in those cases, liability only attaches to the extent that the person who slipped and fell could not be expected to reveal, identify, and avoid the hazard on the floor. So if Susie's walking, let's say at a store, at QFC, for example, and there's a
Mhm.
puddle of water which is not seen on the floor, and there's no A-frame sign that says caution, slippery floor, and if she falls on that slippery surface and sustains an injury, that sounds like a pretty strong liability case. On the other hand, if the same situation takes place except for the liquid on the floor, let's say a bunch of jam spilled, and let's say it's dark in color and it's easily identifiable, and let's also add on top of that a sign that says caution wet floor, and if the fall occurs in that scenario, it's going to be a much harder case to prove on liability.
Because basically, you kind of have to use common sense and use your head as well.
You
If it's obviously hazardous, I mean, don't put yourself in jeopardy, pretty much, of
you
that.
you gotta see where you're going,
Yeah,
folks.
yeah. I mean, things. Use your head. This is legal advice from a personal injury lawyer for you. Look where you're going.
I'd throw my weight behind that advice, Pavel.
Yeah. Um, Another question from Sarah, which is kind of like doesn't make sense, but she says, if I bring the case and I lose, would I be responsible for any cost for any case related costs?
That's a really good question. What was the name of the listener who asked it?
Sarah.
Hi, Sarah. That's a great question. Um, how do I tackle it?
Well,
This actually,
honestly.
this this actually is a great question because it takes me to yet another common legal myth that I was planning to debunk today, and that is it's okay to represent yourself. It's folks, I mean, there are situations where the only option a person has is to represent themselves, not be represented by a lawyer. But let me just say this: one of the first things, pardon me, they taught me in law school was this age-old saying, and it goes like this: a lawyer who represents himself has a
Has a
fool
full
for
for
a
a client.
client. A lawyer who
Yep.
represents themselves has a fool for a client. Remember that. Have it tattooed in your brain every time you decide you know enough about the case to go and represent yourselves. In most situations that I see, for people, there's no need to be represented by themselves, especially in the personal injury realm, where, to be honest with you, there's no shortage of capable personal injury lawyers in town. Just go look for one. Now, going back to the question, you can be ultimately on the hook for the expenses and attorney's fees incurred by the other side if a judge determines that your lawsuit was frivolous. And how do you know whether or not your lawsuit is frivolous? Well, you go and hire a lawyer. So this is definitely something people need to keep in mind. There is this general doctrine, and it's called the American Rule on Attorney's Fees. And it says that by default, each party bears their attorney's fees and costs, but there are exceptions to that rule. And bringing a frivolous lawsuit against someone who ended up incurring fees and costs as a result of that claim is one of those exceptions. I have had cases myself where we got a judgment from the court for thousands and thousands of dollars against a plaintiff who brought a frivolous claim against my client. We ended up proving that we were not at fault. We ended up proving that there was no basis in fact or law to allege liability. And in those situations, you can rest assured the judge is going to make sure that you get the wrath of justice.
Also, in matters of contracts, usually it's pretty much already written in the contract who pays the attorney's fees, and the prevailing side can actually collect attorney's fees from the losing side. But
That's also very true, Pavel. This is actually an
yeah,
exception to the general rule of the American general rule of each party bears their own attorney's fees and costs. Virtually every written contract contains what's called a fee shifting provision or attorney's fees provision. And that language usually says that the prevailing party gets to recover their attorney's fees and costs. This is why it's almost always very risky to go into a lawsuit alleging breach of written contract, because in the end, you might end up spending thousands and thousands of dollars on litigation and not only lose on your claim, but also end up having to pay the other side's attorney's fees and
oh yeah,
costs.
exactly. And really support your idea that you always should hire a lawyer, even if you have legal training, even if you know it all very well. You should always hire a lawyer. For example, I do have a legal training, but I do hire lawyers to handle my affairs all the time. I don't handle any of my legal aspects by myself
So do
because
I.
again,
So do I,
yeah,
Pavel.
yeah, that's there. There we go. It's just one of those things that kind of embedded into me. I like to somebody who's not emotionally involved with my case to handle it. But we have another question from other listeners here. So
Pavel,
yeah,
before we go, I'm glad you mentioned contracts, because that's another thing that I see at the legal clinic all the time, and even in dealing with my business clients. This whole idea that a contract needs to be in writing. This is probably one of the most common misconceptions that I encounter. That is completely false, folks. Your contract does not have to be in writing. There are some exceptions, pardon me, to this rule, but by and large, a verbal oral contract is as good as a written contract. There are reasons why you want to have a written contract, because it specifies and spells out all the terms and conditions of the deal that you've made. But the
you're
deal is
gonna
the
have a
deal.
handshake contract. Yep.
I was just going to say a handshake is just good enough. A lot of people confuse a piece of paper upon which a contract is written, with the concept, the doctrine of a contract. This piece of paper right here is not a contract. A contract is an enforceable agreement between two parties where one makes an offer, another gives an acceptance. They exchange value, i.e., consideration. That's what makes it a binding contract. You can have it written on the back of a napkin. You can do it orally, and it's still going to be enforceable.
You can do it through text messages as well.
You
It's
can
already written. Yeah.
And again, just to put it out there, for any particular fact pattern, you probably should be talking to a lawyer. Do
Yeah.
not enter into an oral contract and then when you get in trouble, say, "Oh, Mordekhov on the podcast, tell me it's okay." No, talk to a lawyer.
Exactly. Exactly. And besides, whatever Davis says right now is not to be construed as attorney-client relationship or legal advice. This is just general information uh, for the for the public. So, David, you even want to give that disclaimer right here.
I am not rendering legal advice here, folks.
Yeah. Question from Brandon. Brandon's asking, David, I just had a car accident. It was not my fault. How much will it cost me to hire you?
That's a good question. Get this all the time. If you're hiring a personal injury lawyer, typically the attorney doesn't get paid until there is recovery. We call it contingent fee. And, I guess the proof is in the pudding. The contingent part of this fee is that the recovery by the lawyer is contingent upon a settlement or a verdict. If I recover nothing from my client, I do not get paid. Now, that's not to be confused with costs. Every lawsuit, every claim results in certain out-of-pocket expenses. And regardless of whether your claim is successful or not, that's going to be your responsibility. So the first thing you need to do if you get in a car accident or some other kind of injury-producing event and you're considering to bring a lawyer on board, go through the cost and benefit analysis. Do I want to spend the time? Do I want to spend the energy? Do I want to spend the money? Because ultimately, and I see this all the time, people end up throwing good money after bad money. Don't do that. I mean, there's definitely a merit to going and consulting with a personal injury attorney if you feel you've been wrong. But just because something happened, just because your neck hurts, just because your back hurts, it doesn't always mean that you are entitled to recovery, that you're entitled to compensation.
So another question we have from Mark, and how to determine what my case is worth?
That's a very hard question to answer. It's kind of like one of those deals. I've been doing it for 20 years and I still don't know how to best answer it. Ultimately, the value of your personal injury case is what a jury awarded. There's no other way to see it. The
How do you know
value,
what to ask from the at fault party or from the insurance company?
well, that depends on who you ask. If you represent plaintiff, you are probably going to be shooting for the moon, hoping you land somewhere between the stars. So if you think that your case is worth $100,000,
Mhm.
when you first start negotiating a settlement, the ask is going to be much more substantial than your actual perceived value of the case. And if you're representing a defendant or if you represent the insurance company, it's the opposite. You start very, very low and then you gradually climb up with your numbers, and the hope is that you meet somewhere in the middle. There are mediators, professional mediators out there who assist the parties to resolve their claims and assist them with establishing a value of a claim. And
Mhm.
what mediators would have you believe is that their job is done when neither party is happy, when the plaintiff is unhappy and the defense is unhappy. That means that they probably hit that sort of sweet spot of what the value is. But again, this is all in the realm of educated guesses based on experiences and cases in the past, but the real value of your case remains unknown until a jury signs a verdict.
Well, it's everybody probably remembers still the case of Stella Liebeck, the infamous person who sued McDonald's for hot coffee. That she got what is like third-degree burns from hot coffee, and she got a bunch of money for it. Well, frankly, she didn't get a penny because she died while the case was up on appeals, as far as I remember. And people think, well, I can just allege, sue, and get millions. So
Yeah. I mean, this is another great legal myth that's been debunked more than once now, and I'm glad you brought this up, Pavel, because first of all, a lot of people know about this McDonald's case. Second, a lot of people think that the lady got a lot of money, and like you mentioned, that's not true. The verdict was $2.8 million, I think. In the end, it went up on an appeal, and the recovery was reduced to $200,000, something like that. And like you mentioned, it wasn't even the lady who received that recovery, it was her estate. Now,
Exactly.
another thing that people don't know about this case is that the reason it ended in front of a jury in the first place is because McDonald's was screwing around with the lady. All she wanted was to have her medical bills paid and a little something for pain and suffering. And McDonald's and, probably their insurance company involved were just offering pennies on the dollar. And that's what in the end triggered that the angry response from a jury. Whenever you see a, $2.8 million
That was a message sent.
word,
Yeah.
the jury is upset. That's your
Yeah.
worst fear as a defense lawyer or as any kind of trial lawyer. If your client upsets your jury, that's where you get catastrophic runaway verdicts.
Yeah. We have a question from McKinsey. McKinsey's asking, is eating while driving illegal in Washington?
Nobody shouldn't do it.
Shouldn't, or they cannot?
You can. You can't eat and drive. From what I understand, I mean, I don't do traffic citations. From what I understand,
I guess next time we'll bring Ellis here to talk about that.
we probably should,
We'll
but
bring her over.
in the end, I think the investigating police officer is going to have ultimate discretion on whether or not they view your driving as being distracted driving. I don't think you're going to get into a lot of trouble if you get pulled over for eating a burger while you're driving. On the other hand, if you're eating a burger while you're driving and you get in a car accident and another participant of that accident ends up with a paralyzed body from the neck down, then you're in serious trouble. Always pay attention, always anticipate what's going to happen, always use a reasonable speed, and always keep an adequate distance, guys.
Perfect. Well, we're gonna be wrapping up. We have a couple more questions, which I'm gonna just sum it up, and you can give people. So we have a question from Kurt: what should I never do after the accident? And question from Aaron: do I need to take pictures right after the accident? What and yeah. So, what do you what are your suggestions to somebody who got into the accident? What they should do, what they shouldn't do, right after, or sometime after the accident. A couple of tips you can give people how to proceed, because let's say somebody's driving around right now listening to our podcast and gets rear-ended. Well, besides calling you, what else they should be and shouldn't be doing?
Mhm. Well, first of all, I hope no member of our audience is ever going to get rear-ended or get into some other kind of unfortunate accident. But hope for the best, prepare for the worst, which is what I always tell my clients. And here's the thing: to stay true to what Pavel and I said earlier today, that this is not an exercise where I'm rendering legal advice. Let me just give you an example of what I did when I had an accident, a minor fender bender about a year ago here in downtown Seattle on Fifth Avenue. I guess I was bumped by an Uber driver, and it was in the midst of a busy intersection. The first thing I did when I came out of my car, I started looking for witnesses. I looked to the left, I looked to the right. I was looking for people to make eye contact with me, either pedestrians or drivers, so that I knew that they saw it. Then the next thing I would do, I would come up to them, I would ask for their phone number, I would ask for their business card, because that's really key. You got to strike the iron while it's hot. And the biggest thing, the biggest mistake people make is they come out and start taking pictures right away, or they come out and they start talking to the other driver right away. Guys, you're going to have time to do that. The first thing you absolutely have to do is make sure you document all of your witnesses. People
Hmm.
don't know to pull over and to leave their number. Most people don't. I've done that before, because I know that an independent eyewitness account probably has more value in a personal injury trial than any other evidence you can present. That's absolutely key. So that's number one. Find your witnesses. Don't even spend the time talking to them. What did you see? How did you see it? Just get their number. You don't want to
Good
be
point.
walking through your potential eyewitnesses and saying, "Oh, You think I ran on? You think I ran a red light? I don't want your number. No, collect all of the numbers, give it to the police officer. The cop is going to call the eyewitnesses and ask them questions. If the cops did not arrive to investigate the accident, keep the numbers to yourself, because guess what? Your insurance company is going to ask you for those phone numbers. Once that's, and not your phone numbers, I mean the eyewitness numbers. And the other thing, once that's done, take pictures. If you have to remove your vehicles from the road because you're creating an obstruction to traffic or anything like that, do not leave the scene until you took all the pictures. Also, if you can get the other driver to quickly jot down a diagram of the way the vehicles are located and get them to sign off on it, and you can even put there not to scale. I mean, obviously, any diagram you create in the middle of a road is not going to be to scale. But if you can get the other driver to admit that this is the positioning of the vehicles, especially in a situation where the cops didn't investigate, do that.
Okay, got it. This is actually a very good point. Not to take pictures of a car damaged right away, because you know what, you're gonna see your damage afterwards anyway. So that's a really good advice. So keep that in mind. Look for witnesses. Or what I do, I have a video cam, a dashboard camera for my car. So that kind of helps, I guess. Every day it just uploads to the cloud. Not everybody has it, but I suggest people do get it. Well, David,
I completely,
yeah,
Pavel, just to come full circle, I completely agree with you on the dash cams. In fact, we just settled a claim involving a significant injury where my client had a dash cam on his car and was running at the time of the accident. And it made my job so much easier because it showed the sequence of impacts and also showed the force of the impact, which might be even more important in some cases than how the accident happened itself, because it definitely demonstrates the traumatic nature of the experience.
got it. Well, David, thank you very much. We're gonna wrap it up. We spent a good almost a little bit more than a half an hour talking about it, and it's very productive. I'm sure our listeners would get some good tips. And guys, if you have any personal injury questions, feel free to send David a DM, and he'll be happy to answer that. Meanwhile, we're just gonna have to wrap it up. And again, make sure you guys follow us on YouTube, subscribe, follow on Instagram, and subscribe on all the podcast platforms where you're listening to your podcast, including Spotify, Apple Podcasts, and other platforms. Meanwhile, I'm just going to wrap it up. And this episode was brought to you by VirtueDesk. VirtueDesk, it's a virtual assistant company that provides virtual assistants for your small and medium-sized businesses at a fraction of a cost. You can hire your own virtual assistant, which is going to be a live person working for you remotely, probably for about anywhere from $8.60 an hour to about $10 an hour, which is a good bargain compared to going to in-house employees. So to look into VirtueDesk, go to myvirtuedesk.com. Again, it's myvirtuedesk.com. And we're going to wrap it up and see you guys on Thursday. And David will be talking to you on Monday again. Thank you very much.
Thanks, Pavel.
Yeah.
See you next time.
See you.